Hello. Welcome back to Module 4, the American Republic in Practice. Today, we will go over Section 2, Branches of the Federal Government. In this video, you will learn how the Constitution established the three branches of government. We'll look at specific articles and clauses that grant these branches and their subordinate components the power to fulfill their constitutional roles. Article 1 of the Constitution establishes the legislative branch. Section 1 vests all federal legislative powers in a bicameral Congress that serves as the foundation of the national government. This structure flows from the social compact as understood by the framers and allows the people's representatives to act together for the common good. Section 7 lays out the legislative process by which bills become law. We already discussed the procedures of lawmaking in Module 2, Section 10 of this video series. See that video for more details. Article 1, Section 2 describes the arrangement and structure of the House, including the three qualifications of representatives and their terms of office. Members of the House have to be at least 25 years old, been a citizen for 7 years, and be a resident of the state from which he or she is elected. To maintain their accountability, sitting representatives face re-election every 2 years. A census is held every 10 years for reapportionment. Representatives are directly elected by their constituents. Several framers had originally wanted to make property ownership a requirement for voting in House elections. However, Benjamin Franklin argued that many common people had served in the Revolutionary forces and had already earned their suffrage. Finally, Clause 5 grants the House the sole power of impeachment, including the impeachments of presidents. Article 1, Section 3 performs the same function as Section 2 does for the House. The section details how senators are elected, their qualifications, and their powers. As noted elsewhere, the 17th Amendment changed the method of election from the state legislatures to a direct vote by the electorate. Thus, Clause 1 and part of Clause 2 have been superseded. Clause 3 stipulates that senators must be at least 30 years old and have been a citizen for 9 years. Clause 6 gives the Senate the power to try all impeachments, which balances the power held by the House to impeach. Article 2 enumerates the powers and responsibilities of the President. Section 1, Clause 1 vests the executive power in the President, including setting their terms of office at 4 years, and explaining the procedure for electing them through the Electoral College. Clauses 2, 3, and 4 define how the Electoral College elects the President. In the simplest terms, each state appoints electors to serve in the Electoral College, the number of electors being based on the state's population. Electors cast ballots for the candidates for president and vice president. Congress meets to count the votes and determine the president and vice president. We'll talk more about the Electoral College in Module 5. Clause 5 fixes the requirements for the office. Candidates must be 35 years old, must be natural-born citizens, and must have lived in the United States for at least 14 years before becoming president. Writing in Federalist No. 69 in 1788, Hamilton outlined the nature of the proposed presidency in order to address the concerns of anti-federalists that the president would function as an elected monarch. He emphasized that the president is an elected official with clearly defined and limited powers, accountable to the people and the law, not an American king. Hamilton's description mirrors Section 2 of the Constitution. Section 2 outlines the President's powers. The President is the Commander-in-Chief of the Armed Forces. Is assisted by department heads who advise on matters associated with their duties. Can grant pardons, commutations, and reprieves to those convicted of federal crimes. Can enter into treaties with foreign nations subject to Senate approval, and appoints government officials, including ambassadors, department heads, and federal judges, with Senate confirmation. The Constitution grants powers over military and armed conflicts to both the Congress and the President. Article 1, Section 8, Clause 11 gives Congress the power to formally declare war on another nation. As mentioned, Article 2, Section 2 bestows on the President the power to direct the military as Commander-in-Chief. These provisions both provide a check on power and serve to require cooperation between the branches. The Congress declares war and appropriates funding for the armed forces, while the President directs the military leadership. Civilian leadership of the military is a bedrock principle of the country, and it starts with the President's constitutionally authorized duties. The last time Congress formally declared war was during World War II. Since then, American troops have been deployed by way of congressional resolutions for military operations, such as the Korean War, the Vietnam War, the Persian Gulf War, the Afghanistan War, and the Iraq War. But, since Congress did not declare war, these are not considered official wars of the United States, despite the loss of blood and treasure. In response to the American involvement in Southeast Asia, Congress passed the War Powers Resolution Act of 1973. The resolution requires the President to communicate to Congress within 48 hours when troops are being committed to an armed conflict. Further, the President is required to remove all troops after 60 days if Congress has not granted an extension. Following the September 11 attacks, for example, Congress passed the Authorization for Use of Military Force Against Terrorists, or the AUMF, which granted the President all necessary power to wage war on nations or individuals associated with the attacks. As mentioned, Article 1 of the Constitution vests the legislative power in Congress. But, no clause explicitly gives Congress the power to create federal departments and agencies. This unspecified power has been found in Section 8, Clause 18, known as the Necessary and Proper Clause, which grants Congress the broad authority to enact laws that support the powers explicitly mentioned in the Constitution. Thus, the Congress has the sole power to establish federal government offices. Additionally, the legislative branch may create government offices that are not explicitly mentioned in the Constitution in order to fulfill the enumerated powers. As an aside, the Necessary and Proper Clause is the foundation for the majority of federal laws. Article 2, Section 2, Clause 2, or the Appointments Clause, outlines the procedure for appointing particular officials. The President has the authority to appoint principal officers, subject to the Senate's confirmation. Thus, in another example of separation of powers, Congress's authority to create officers is disconnected from the President's authority to fill them. But the President, department heads, and the courts have the ability to appoint inferior officers. Determining the difference between principal and inferior in the Appointments Clause has been the subject of legal debate. A working definition of principal officers is drawn from Section 2, Clause 1, the principal officer in each of the executive departments. The 25th Amendment uses this same phraseology. In other words, these individuals are the department and agency heads, such as the Secretary of State, the Attorney General, the Secretary of Defense, the Secretary of the Treasury, and the Secretary of Commerce. Supreme Court justices, federal judges, and ambassadors have also been found to be principal officers. Inferior officers are those individuals appointed to their offices by the principal officers, including undersecretaries, deputy directors, or U.S. attorneys. The key distinction is that principal officers report directly to the President, while inferior officers report to principal officers. Additionally, the Supreme Court has found that the Constitution imposes essential limits on Congress's ability to influence or direct the acts of officers once they are appointed. Article 3 of the Constitution establishes and empowers the judicial branch. In Section 1, the judicial power of the country is vested in a Supreme Court and any lesser courts that Congress may decide to create. Thus, today, we have a three-tier federal court system, the Supreme Court, the Circuit Courts, and the District Courts. Section 1 also stipulates that judges shall hold their offices during good behavior, which has been interpreted to grant them a lifetime appointment. The section also says that judges shall, at stated times, receive for their services a compensation which shall not be diminished during their continuance in office. These 2 points are meant to ensure that judges be independent and decide cases on their interpretation of the law, without concerns for popular opinion or the wants of influential people. Hamilton noted in Federalist No. 78 that judicial independence is the best expedient which can be devised in any government to secure a steady, upright, and impartial administration of the laws. The courts are focused on only hearing actual cases and controversies. In order to bring suit in court, a plaintiff must demonstrate that harm has occurred. The court's rulings must have practical effect. They do not issue advisory opinions on the constitutionality of laws or the legality of actions without addressing a specific case. As you've seen, the Supreme Court is the only court explicitly named in the Constitution. It has original jurisdiction over certain types of cases, such as disputes between the states or those involving ambassadors and other diplomats. Congress has also granted the court through various statutes appellate jurisdiction over other matters. The court's primary tasks are to interpret the meaning of a specified law, determine whether that law is relevant to a particular set of facts, and rule on how the law should be applied. The majority of the court's caseload is appellate in nature, and its rulings on federal law are final. Lower courts are required to follow the precedents set by the Supreme Court's decisions. Currently, there are 9 justices who sit on the bench, 1 Chief Justice and 8 Associate Justices. The Supreme Court has heard an immense number of cases in its 200-year-plus history. One landmark case you have probably heard about is Brown v. Board of Education, which challenged the constitutionality of segregation in the Topeka school system in 1954. The court reversed an earlier decision in Plessy v. Ferguson from 1896 and declared that separate schools are inherently unequal. If you've ever watched a cop show, you've heard a police officer read a suspect his or her rights. This warning originates in the 1966 case Miranda v. Arizona, in which the Supreme Court ruled that police must inform suspects of their rights to remain silent and to counsel before questioning. The Federal Circuit is comprised of 12 regional courts of appeals and 1 U.S. Court of Appeals for the Federal Circuit, which hears specialized cases involving things like patents, trademarks, government contracts, and certain claims against the U.S. government. The judges typically sit on a 3-member panel and determine whether the law was applied fairly and correctly in the district courts. They do not retry cases or hear new evidence, but instead review the lower court's procedures and decisions. They may also hear original proceedings that were filed directly with the Court of Appeals. Courts of Appeals decisions are final unless the Supreme Court chooses to take up the case, and binding on the lower courts within the same circuit. Kansas is located within the jurisdiction of the 10th Circuit Court of Appeals, which includes Colorado, New Mexico, Oklahoma, Utah, and Wyoming. As of June 2025, there are 179 authorized judgeships in the U.S. Court of Appeals. The federal trial courts are organized into 94 federal districts. They are the beginning point for most federal cases. The district judges hear civil and criminal cases and are responsible for the pretrial process and the conducting of trials. They are in charge of a variety of procedures, including handling the selection of juries and instructing the jurors throughout a trial, ruling on admission of evidence, hearing pleas in criminal cases, resolving any issues surrounding the acceptance of the verdict and entry of judgment, and sentencing the defendant if a trial results in conviction. Kansas is served on the federal level by the U.S. District Court for the District of Kansas, with locations in Wichita, Topeka, and Kansas City. As of June 2025, there are 677 federal district court judges in the United States. Next time. In the next video, we'll take the basic idea of the three branches of government and apply it to the state government of Kansas. We'll also look at the county and city governments that have the most bearing on Barton Community College. Until then, thank you for your time. If you want to learn more about the subjects we have discussed, here are the sources used for this section.